ഭയങ്കര തമാശ എന്ന് പറഞ്ഞാൽ ഞങ്ങൾ അങ്ങനെയാണ് മനസ്സിലാക്കുന്നത്, ഞങ്ങൾക്ക് അങ്ങനെയാണ്. അവരോട് ചോദിക്കാൻ ഒറ്റ ചോദ്യമേ ഉള്ളൂ, കോൻ ഹേ, ഹു ആർ യു, ഹു ആർ യു? എന്ത് അധികാരത്തിലാണ് നീ ഇത് പറയുന്നത്? ആരാണ് നിനക്ക് ഈ പുസ്തകം? അതായത് സഭയിൽ നിന്ന് കട്ടെടുത്തൊരു പുസ്തകം എടുത്തിട്ട് സഭയെ തെറി വിളിക്കുകയാണ്. സഭയിൽ നിന്ന് കട്ടെടുത്താണിത്. കാരണം എന്താണ്? ഈ ന്യൂ ടെസ്റ്റമെന്റ്, ഞാനതിലേക്ക് വരാം. ന്യൂ ടെസ്റ്റമെന്റ് ഉപയോഗിക്കാൻ അവകാശം ഉണ്ടാവണമെങ്കിൽ ആ ന്യൂ ടെസ്റ്റമെന്റ് ഇതാ എന്ന് പറഞ്ഞ് തന്ന സഭയോട് അനുവാദം ചോദിക്കണം. അല്ലെങ്കിൽ ഇത് കയ്യിലെടുക്കാൻ അവകാശമില്ല. കോപ്പി റൈറ്റ് പ്രകാരം കേസ് കൊടുത്താൽ ജയിലിലാവും. ഞാൻ പറയുന്നത്, അതായത് നമ്മുടെ വീട്ടിൽ നിന്ന്, നിങ്ങൾക്കറിയുമോ, അമേരിക്കയിൽ ഒക്കൽഗോമയിൽ സാത്താൻ സേവ നടക്കാൻ, വിശുദ്ധ കുർബാന മോഷ്ടിച്ച് സാത്താൻ സേവ നടക്കുന്ന സമയത്ത് ആ സാത്താൻ സേവ നടക്കാതെ പോയതിൻ്റെ കാരണം ഒരു ചെറുപ്പക്കാരൻ കേസ് കൊടുത്തു. ആ കേസ് കൊടുത്തിട്ട് അവൻ പറഞ്ഞു, ഇവർ കോൺസെക്രേറ്റ് ചെയ്യപ്പെട്ട തിരുവോസ്തിയാണ് മോഷ്ടിച്ചെടുത്ത് ഈ സാത്താൻ സേവ അർപ്പിക്കുന്നതെങ്കിൽ അവർ മോഷ്ടിച്ചെടുത്താണ്. കോൺസെക്രേറ്റഡ് ഹോസ്റ്റ് കഴിഞ്ഞ 2000 വർഷമായിട്ട് സഭയുടെ പ്രോപ്പർട്ടിയാണ്. ആ സഭയുടെ പ്രോപ്പർട്ടി മോഷ്ടിച്ചെടുത്ത് അതിനെ പരിഹാസ വിഷയമാക്കുന്നതിനെ വിലക്കണം. കോടതി ആ വാദം അംഗീകരിച്ചു. കോടതി അംഗീകരിച്ചിട്ട് അവരോട് പറഞ്ഞു, സാത്താൻ സേവ നടത്താൻ, യൂക്കറിസ്റ്റിക് ഹോസ്റ്റ് വെച്ച് സാത്താൻ സേവ നടത്താൻ പറ്റില്ല. ഇന്ന് കേരളത്തിൽ ആരെങ്കിലും കേസ് കൊടുത്താൽ പല ആളുകളും ജയിലിലാവാൻ ഇത് മതി. കാരണം എന്താണ്? അതായത് സഭയിൽ നിന്ന് കിട്ടിയ ഒരു പുസ്തകം, നമ്മുടെ മാന്യത കൊണ്ടാണ് നമ്മൾ കേസ് കൊടുക്കാത്തത്. കാരണം കർത്താവ് അങ്ങനെ കേസ് കൊടുക്കരുതെന്ന് പറഞ്ഞിട്ടുള്ളത് കൊണ്ടാണ് നമ്മൾ കേസ്, ശരിക്കും പറഞ്ഞാൽ ഇത് കേസ് കൊടുക്കേണ്ട വിഷയമാണ്. ഞാൻ പറഞ്ഞു വരുന്നത്, എവിടുന്നെങ്കിലും ഒരാൾ, നമ്മൾ ആരെയും ദുഷിക്കുകയല്ല, മറിച്ച് ഇതിനകത്തെ ഒരു കോമഡി നമ്മൾ മനസ്സിലാക്കണം. എവിടുന്നെങ്കിലും ഒരാൾ ഇന്നൊരു പുസ്തകം എടുത്തിട്ട് എനിക്കിങ്ങനെയാണ് തോന്നുന്നത്, നോ നോ നോ, യു ഡോണ്ട് ഹാവ് എനി അതോറിറ്റി ടു ഇന്റർപ്രറ്റ് ദിസ് വേഴ്സ് ഇൻ യുവർ വിംസ് ആൻഡ് ഫാൻസി. അങ്ങനെ അനുവാദമില്ല നിനക്ക്. പിന്നെ മറിച്ച് നീ ചോദിക്കണം, കഴിഞ്ഞ 2000 വർഷമായിട്ട് എങ്ങനെയാണ് സഭ ഇതിനെ വ്യാഖ്യാനിച്ചത്? ഇതാണ് അതിനകത്തെ അടിസ്ഥാനപരമായ ഒരു പ്രശ്നം. അപ്പം അതുകൊണ്ട് നമ്മൾ ഈ സഭ എങ്ങനെയാണ് ഇതിനെ പ്രബോധിപ്പിച്ചതെന്ന് മനസ്സിലാക്കി.
നമ്മുടെ കുടുംബത്തിലെ ഒരു വിഷയം, നമ്മുടെ കുടുംബത്തിലെ ഷെൽഫിൽ ഇരിക്കേണ്ട ഒരു വിഷയം, ഇത് ഫോട്ടോസ്റ്റാറ്റ് എടുത്ത് ഇത് മറ്റുള്ളവർക്ക് കൊടുത്താൽ നിങ്ങൾക്ക് കേസ് കൊടുക്കാം, നിങ്ങൾക്ക് കേസ് കൊടുക്കാം. അപ്പോസ്തലിക സഭ എന്തായാലും അതിന് മുതിർന്നിട്ടില്ല ഇതുവരെയായിട്ടും. ഇത് കേസ് കൊടുക്കേണ്ട ഒരു കാര്യമാണ്. കാരണം ഇതിന്റെ എല്ലാ അവകാശങ്ങളും ഉള്ളത് സഭയ്ക്കാണ്. ഇവിടുത്തെ അപ്പോസ്തോലിക സഭ ഒരുമിച്ച് നിന്ന് കേസ് കൊടുത്തു കഴിഞ്ഞാൽ ഒരു ഗ്രൂപ്പിനും ഈ ബൈബിൾ കൊണ്ടുപോകാൻ പാടില്ല. ഇത് ബൈബിൾ സഭയുടെയാണ്. ഇത് അംഗീകരിക്കാൻ പല ആൾക്കാർക്കും ബുദ്ധിമുട്ടുണ്ടാകും. പക്ഷെ ഇതാണ് അതിന്റെ സത്യം.
Here in this short video, the Roman Catholic priest is claiming that it is the Catholic Church which has the copyright of the Bible, and that those who criticize the Catholic Church using the Bible have stolen the Bible from the Catholic Church, and that the Catholic Church can go to the court against them. I think the speakers have thoroughly misunderstood much about the Bible, including its history and content. Otherwise, they would not have committed such theological and historical blunders. I also doubt whether they know the God, who is the primary author and owner of the Bible, who became a man and gave himself for mankind on the cross. Do you think that the God who gave himself for the mankind will not freely give the Bible to the mankind? Do you think this God will leave the Bible to the mercy of the Catholic Church? One has to be extremely ignorant, blind, parochial and religiously selfish to think and argue like that. Moreover, the primary writers of the Bible were all Jewish, and they had nothing to do with Roman Catholic Church, which came into existence in the 3rd century, at the instance of Emperor Constantine. Furthermore, all the New Testament books were given by God to the 1st century Pentecostal Church. It was out of this 1st century Pentecostal Church that from 3rd century onwards, different church groups like Catholic Church started emanating. Moreover, the so-called love of the Catholic Church towards the Bible is dubious. It has a history of suppressing the Bible truth, Bible burning and burning the Bible translators, for many centuries. It was the various Protestant Bible societies, which liberated the Bible, and made the Bible available to the world, in the modern times. Under the rule of the Catholic Church in the Middle Ages, the common people were not allowed to possess and read the Bible. Perhaps, if they understand some basics about the broad concepts such as copyright, patent, trademark, public domain, fair use, etc., they might not repeat the same mistakes again. We should understand that most of the religious scriptures and classics are in the public domain. Since most of the world's major religions have been practiced for over 1,000 years, their original scriptures are in the public domain. This includes scriptures such as the Torah, the Bible, the Quran, and the Bhagavad Gita. However, most translations of these works are far newer, and translations are often under the copyright of the translator. Religions often claim that their works were created by God, or divine beings. Hence, works created by such beings are not eligible for copyright, and churches cannot claim copyrights on their behalf. On the other hand, as God and the human writers intended the well-being and eternal salvation of all mankind, it is free, and is to be given free. Moreover, God allows reasoning. He said, "Come, let us reason together." God is not afraid of criticism. Rather, God welcomes reasoning and constructive criticism. But some selfish persons, claiming monopoly for their religion, will claim copyright for the scriptures. All such claim is invalid. The Bible in general is of public domain, but many translations are not. If you want to reprint the Bibles, or do your own translation, you need to find out what versions are in public domain and which are not. The public domain consists of all the creative works, to which no exclusive intellectual property rights apply. Those rights may have expired, been forfeited, expressly waived, or may be inapplicable. As examples, the works of Shakespeare, Beethoven, Da Vinci, etc. are in the public domain, either by virtue of them having been created before the copyright existed, or by their copyright term having expired. Some works are not covered by a country's copyright laws, and are therefore in the public domain. Other works are actively dedicated by their authors to the public domain. A public domain book is a book with no copyright, a book that was created without a license, or a book where its copyrights expired, or have been forfeited. In most countries the term of protection of copyright expires on the first day of January, 70 years after the death of the latest living author. The longest copyright term is in Mexico, which has life, plus 100 years for all deaths, since July 1928. A major limitation on copyright is that copyright protects only the original expression of ideas, and not the underlying ideas themselves. Most jurisdictions recognize copyright limitations, allowing fair exceptions to the creator's exclusivity of copyright, and giving users certain rights. Some older Bible translations are in the public domain, and may be freely reprinted, quoted, and copied without any restrictions at all. The King James Version is the most well-known of these. And if you have the skills and dedication, there is nothing stopping you from creating your own Bible translation. There are online projects dedicated to doing just that. The Hebrew, Aramaic, and Greek texts of the Bible are public domain. When a work has been around long enough, currently 95 years after the first publication or 70 years after the author's death, it enters the public domain, and is therefore allowed to be reproduced at will. According to the Copyright Act, any work published prior to 1923 is in the public domain. This means many older translations are fair use, King James Version, Revised Standard Version, etc. Fair use is a doctrine that permits limited use of copyrighted material, without having to first acquire permission from the copyright holder. Fair use is one of the limitations to copyright, intended to balance the interests of copyright holders with the public interest. It is the publisher of the Bible who has the copyright, not any church. Copyrights belong to whichever publishing house that published a particular version. It is the publisher of the Bible who has the copyright, not any church. This is because all the translators and biblical experts who worked so hard and so long to give good translations of the original texts. Most of us are not proficient in Hebrew, Aramaic, and Greek, and so we depend upon these scholars and experts to offer us good translations, which as closely as possible, reflect what is found in the best manuscripts available. So, in that sense the translators have played a role in authorship as well. So, if they gave much time and effort to these translation projects, as Paul says, laborer is worthy of his hire. So, the translated work has the intellectual property rights, as well as some sort of remuneration, for the work provided. Even though the Bible is God's word, God worked through the human authors to bring about the 66 books of the Bible. And, to a lesser extent, the modern scholars to help in the ongoing work of translation. Each publisher who pays for a new translation, or adds any notes, maps, etc. to the version he publishes, can copyright the new content of his version. So, most Bibles you pick up, will have legitimate copyrights. This is because, producing a new translation of a document like the Bible, takes thousands of man-hours which costs a lot of money. Hence, the publishers have a legitimate right to restrict the free copying and distribution of that work. While some would work on such a project without pay, in our economy it is not very practical to expect enough scholars, editors, etc. to participate, probably investing hundreds or thousands of personal hours, without some compensation. Copyright, patent, and trademark are all different types of intellectual property. A copyright is a collection of rights, automatically vested to you, once you have created an original work. As the copyright owner, you have the authority to keep it, to transfer them individually to one or more people, or to transfer them collectively to one or more people. This can be accomplished through licensing, assigning, and other forms of transfers. The power of copyright allows you to choose the way your work is made available to the public. Copyrights protect creative works. Whether it's a book, a piece of music, a sculpture, an architectural drawing, a movie, a fashion design, or academic article, the intellectual property right in the work itself is a copyright. As soon as the work is fixed, written down, sculpted, recorded, or otherwise set down in an enduring form, the creator owns the copyright. You don't even need to do anything to own a copyright, other than make something, though you do have to register it, if you want to enforce it in court. Only the copyright owner has the right to make copies, distribute copies, perform, display, or make derivative works of the copyrighted work. A copyright lasts for the life of the author, plus 70 years, for works made for hire, 95 years from when they are first published. There's no need to renew or maintain a copyright. A copyright is a legal restriction on duplicating someone else's work, to protect the right of the original producer of a work to get fair pay for his work. Copyright is granted to the author on the creation of the work. Copyright is a legal right created by the law of a country that grants the creator of an original work exclusive rights, for its use and distribution. This is usually only for a limited time. The exclusive rights are not absolute but limited by limitations and exceptions to copyright law, including fair use. Now we will see what is a patent. Patents protect inventions. If you invent a new mousetrap, a new way to make hats, a medicine, or anything else that someone can make or do, you can protect it with a patent. Unlike with a copyright, you must apply for a patent, and define exactly what you've invented and want to protect. Basically, a patent is a trade in which you make your knowledge public, in exchange for a monopoly on a certain use of that knowledge. Unless you get a patent, you have no patent rights, and if you don't apply for a patent soon enough, you can miss your chance to get one. Patent owners have the exclusive right to make, use, or sell the invention covered by the claims of their patent. Patents can last for 20 years after you file the application but need to be maintained or they will expire early. The primary goal of the patent law is to encourage innovation and commercialization of technological advances. A patent protects inventions. These inventions can include new and useful processes, machines, manufactures, compositions of matter as well as improvements to these. Certain computer programs may fall within the subject matter protected by both patents and copyrights. In this respect, the patent system complements copyright protection by providing protection for functional aspects of the software, which are not protected by copyright. Now, we will see what is a trademark. The term trademark is often used in a general sense to refer to both trademarks and service marks. Examples include brand names, slogans, and logos. Trademarks protect symbols and identifiers. A trademark is a word, phrase, symbol, or design that identifies and distinguishes the source of the goods of one party from those of others. A service mark is a word, phrase, symbol, or design that identifies and distinguishes the source of a service rather than goods. A trademark can be anything that lets consumers know the source of a good or service. Traditionally, a trademark is a name or symbol, the shape of a product, its packaging, or even a color or sound. You have trademark rights as soon as you use a particular mark to identify your goods or service, but it's always best to register your trademark to best protect your rights. A trademark can last forever if you keep using it, and some of them are hundreds of years old. But in some countries, the trademark registrations must be renewed every 10 years by showing continued use. Trademarks also do not protect generic names, so you cannot prevent other coffee shops from calling their coffee, coffee. In the light of this detailed discussion, kindly understand that God is the primary author and owner of the Bible. Instead of bargaining to possess and control the Bible, please understand and preach the message of the Bible. May God bless you.